Let's begin then. So welcome to the guest speaker program of the US-Asia Law Institute at NYU School of Law. I'm Catherine Wilhelm, the Institute's Executive Director. And today we have another talk in our long-running series about the legal status of Taiwan. As many of you know, over the past year or 13 months, we've invited speakers to talk about Taiwan from a number of different legal perspectives, from that of international law, US law, PRC law, and Taiwan's own domestic law. So today we are raising a question that implicates both international and domestic law, which is namely, what do trade agreements say about Taiwan's status? So everyone knows that Taiwan is very isolated diplomatically, with very few governments giving it official recognition, but it's a major participant in the global trading system. It has investment or trade agreements with more than 3 times as many states as offer it diplomatic recognition. So our speaker today, Pasha Hsieh, has written a series of papers examining these economic agreements and raising the question of what significance they have for Taiwan's status in the world. Professor Hsieh is the Lee Kong Chian Professor of Law at the Singapore Management University School of Law, where he also holds a chair in EU-ASEAN Law and Relations. His teaching and research focus on international economic law, public international law, EU and ASEAN law, and Asian legal studies. And you can find his full bio on our website. But I guess I should add that he is from Taiwan and began his legal studies there. So Pasha, as I was mentioning to you a moment ago, you're one of our favorite repeat guests. This is at least your 3rd or 4th time in the last few years that you've been a guest speaker to come enlighten us on various points of law. So I'm going to give you the mic to make your opening remarks, and then, as usual, we'll turn to some questions from me and from our learned audience.
Thank you, Catherine, for your kind introduction. As Catherine mentioned, my research focuses on trade agreements and recognition policy. These 2 topics may sound quite different, but they can be closely intertwined. And I'm a lawyer by training, and my Taiwanese background makes me quite interested in issues of recognition and non-recognition in international law. At some point, I came across works written by political philosophers and IR scholars. They discuss recognition theory, but often from very different angles. They frequently refer to what legal scholars have written, but not the other way around. So my goal is to bridge the gap between law and political science on the issue of recognition theory. A few years ago, I received 2 separate messages from my friends who work closely with European and Asian governments. Interestingly, they both asked me the same question: whether trade agreements with Taiwan would constitute implied recognition. That was the first time I realized that this topic carries real practical significance for foreign governments. My talk today focuses on my forthcoming article on the U.S.-Taiwan trade agreement, which is part of my broader book project titled Beyond Non-Recognition. Let me first discuss how international lawyers and IR scholars understand recognition. First, recognition, statehood, and sovereignty are actually 3 distinct concepts. Recognition is a unilateral political act with legal consequences, such as entitlement to sovereign immunity. Under international law, state recognition and government recognition are also different. The recognition of states concerns whether an entity is recognized as an international person, whereas the recognition of governments concerns which government represents the state. International law textbooks usually classify Taiwan or the Republic of China, ROC, under government recognition. But today, what really matters in legal practice is state recognition, whether Taiwan can be treated as if it were a state. Recognition can also be explicitly conferred or implied. Scholarly work and judicial cases suggest that concluding a treaty can amount to implied recognition. An example is the FCN Treaty, Treaty of Friendship, Commerce, and Navigation. So now a controversial question is whether a modern trade agreement can be considered as treaty in this sense. Recognition in international law involved the debate between constitutive theory and declaratory theory. Influenced by positivism, constitutive theory holds that recognition is essential to statehood. In contrast, declaratory theory asserts that recognition only serves as a declaratory acknowledgement of that fact. For most international law, the debate is largely settled. The Montevideo Convention clearly says that the political existence of a state is independent of recognition. So that's the declaratory theory. Next, what is sovereignty? It includes both internal and external sovereignty. External sovereignty, also known as international legal sovereignty, relates to a state's independence and its recognition by other states. So now we know statehood and sovereignty overlap in the element of independence, but diverge when it comes to recognition. International law largely treats recognition and non-recognition as a binary exercise, either black or white. When we talk about non-recognition, it is often associated with the duty not to recognize illegally annexed territories. A typical case is the Stimson Doctrine regarding Manchukuo, Japan's puppet state during World War II. However, the ICJ created a very narrow exception in the Namibia advisory opinion. The court said that certain property law acts, such as birth and marriage registration certificates, could be recognized despite the non-recognition of the illegal regime. Now, let me explain the evolution of recognition in political science. Hegel first developed recognition theory in the context of intersubjective human behavior. According to him, the existence of the self depends on the recognition of the other. A classic example is that the existence of a master depends on the recognition of his or her slave. From around 2010, a new trend emerged. IR scholars have applied Hegel's recognition theory to interpret interstate relations. Traditionally, neorealists argue that states are primarily motivated by the pursuit of security and material power. Modern IR scholars argue that this is not the whole story. And influenced by the constructivism, they claim that struggles for recognition of identity, such as prestige as a great power, also motivates state behavior. Another group of IR scholars goes further. They argue that in addition to the psychological element of identity, states also struggle for status, which demonstrates dignity based on normative standards. International law is particularly relevant here as it provides normative benchmark for status recognition. Overall, IR scholars believe that recognition is still constitutive and that it is not binary. They are diverse and gradual forms of recognition, even within the space of non-recognition. However, they admit that these forms are difficult to measure. I try to address this methodological challenge by using trade agreements as a lens. My overall argument is that collective forms of legal recognition under trade agreements can blur the line between implied recognition and non-recognition. The extent of legal recognition, in fact, far exceeds the Namibia exception that I talk about. After discussing the theories, let me look at the empirical information on U.S. trade agreements. Traditionally, there are three types of agreements: FTA, Free Trade Agreement; BIT, Bilateral Investment Treaties; TIFA, Trade and Investment Framework Agreements, which provides a framework for dialogue with the aim of eventually reaching a BIT. Taiwan currently has 9 FTA-style agreements, including EFTA with China, as well as more than 30 bilateral investment treaties. But in the US, these traditional approaches are no longer the favored method. Both the Biden and Trump administrations have relied on non-traditional agreements such as the IPEF or reciprocal trade agreements. So the table in the middle shows that so far, the US only concluded 3 full-fledged FTA in the Indo-Pacific with Singapore, Australia, and Korea. Most countries, including Taiwan, have TIFAs. US-Taiwan TIFA talks were suspended after 2016 and only resumed in 2021. You can also look at the trade bloc diagram on the right. You will see that the US and India are not parties to major FTAs, such as the CPTPP or the RCEP. Taiwan is an APEC member and has attempted to join the CPTPP, and Timor-Leste just joined ASEAN last month. Obama initiated the TPP, Trans-Pacific Partnership, but Trump withdrew the US in 2017. Japan and Canada salvaged the deal, creating the CPTPP based on the original TPP. The UK recently joined the deal, increasing its share of global GDP to 15%. Biden viewed the IPEF as a key pillar of his Indo-Pacific strategy. The IPEF is not an FTA, as it contains no tariff or service commitments. It's organized around a four-pillar structure, with each pillar intended to result in a separate agreement. Except for the trade pillar, agreements under the other three pillars on supply chains, the clean economy, and the fair economy have been signed. Some ASEAN countries were quite concerned about Taiwan's participation in the IPEF. As a result, Biden signed a separate deal called the U.S.-Taiwan Initiative on 21st Century Trade, which is the focus of my article. It is like a mini IPEF. Both sides signed the first agreement under the initiative in 2023, and Congress passed the Implementation Act for this agreement. And as we know, Trump attended the ASEAN summit last month and concluded so-called reciprocal trade agreements with Cambodia and Malaysia. Taiwan is now negotiating a similar agreement. Let's now zoom in on US-Taiwan agreements. Toward the end of World War II, the United States signed the FCN Treaty with the ROC government. This treaty represents the very first generation of US trade agreements. The FCN Treaty remains valid in both the United States and Taiwan under the Taiwan Relations Act, which Congress enacted following President Carter's derecognition of the ROC. From the 1990s, bilateral interactions became more normalized, with the signing of the TIFA in 1994 and the Customs Mutual Assistance Agreement in 2001. The two sides also established additional dialogue mechanisms, and all of this initiative culminated in the US-Taiwan Initiative First Agreement in 2023. What are the policies that prompted the US-Taiwan trade agreement? And of course, it relates to Chinese President Xi's escalating approach to Taiwan, including gray zone military actions and economic coercion. China has also tried to squeeze Taiwan's international space by persuading 10 countries to switch recognition to Beijing since 2016. We should know that the termination of diplomatic relations does not automatically lead to the termination of FTAs. Panama is an example. It severed ties with Taiwan in 2017, but the FTA continued to remain operational. China has also pursued a lawfare strategy, which is quite unknown to many people in the West. In many cases, countries only acknowledge or noted the PRC's position that Taiwan is part of China in their diplomatic communiques. As reflected in recent joint statements with certain ASEAN countries, China has sought to eliminate this ambiguity by requesting that country explicitly recognize its sovereignty over Taiwan. U.S. congressional members have regularly written letters to the USTR and the president urging the signing of an FTA with Taiwan. There has also been various pro-Taiwan legislation since the Taiwan Travel Act, as well as a bill challenging the PRC's distortion of UN General Assembly Resolution 2750A. And this aligns with similar resolutions passed by the parliaments of many other countries, including Australia, the EU, and the UK. To understand the US-Taiwan initiative, we first need to determine the legal nature of the trade agreement. as only a treaty can trigger implied recognition. Under WTO law, the answer is quite straightforward. The U.S.-Taiwan agreement is neither an FTA nor an interim agreement, as it does not meet the substantially altered trade requirement. But it doesn't fully answer the question. How about the VCLT, the Vienna Convention on the Law of Treaties? The VCLT adopts a broad view by defining a treaty as an international agreement concluded between states. The VCLT also envisions that the agreement may be concluded by a subject of international law other than a state. The ICJ has also broadly interpreted treaties, saying that all instruments such as minutes of meetings or MOUs can be regarded as treaties so long as they have binding character. From its substance, the U.S.-Taiwan Initiative First Agreement is far more detailed than the FCN treaty that I alluded to. And of course, for implied recognition to arise, there must be the government's unequivocal intent. In 1929, the Court of Appeals for the Ninth Circuit dealt with an interesting case. It's actually about an insurance policy that was signed by the Beiyang government in Beijing. But the Chiang Kai-shek's government in Nanjing demanding payment. So, two ROC problem. The court held that due to various factors, including the signing of a treaty, implied recognition was accorded to Chiang's ROC government. In the 2000s, there were two interesting cases about Singapore Airline, and both cases involved Taiwan's sovereign immunity. And the Singapore Court of Appeal say that the bilateral agreement and MOU only indicated cooperation, and Singapore did not have intent to recognize Taiwan, and quite different from the Canadian court's decision. The U.S.-Taiwan Initiative also involved the allocation of trade authority between Congress and the president. The traditional model was based on congressional executive agreements under the TPA, Trade Promotion Authority. Under this model, Congress first establishes the overall content of the agreement on a bipartisan basis, and as so long as the USTR negotiates accordingly, the agreement can be fast-tracked for approval. Biden's view was that the first agreement required no changes to U.S. law. As it is an executive agreement, congressional approval was not required. Apparently, Congress disagreed. Its position is that any binding agreements like this one requires congressional ratification. That is why Congress enacted the Implementation Act for the first agreement. The consultation requirements under the Act are more detailed than under the TPA. The Act even allows congressional members to participate in the U.S. delegation. Overall, the Act increases the recognition of the U.S.-Taiwan agreements to the status of a congressional executive agreement, making it more durable because the president cannot simply exit the agreement. Now, what does the U.S.-Taiwan Initiative actually recognize? From an international perspective, it recognizes key statehood criteria. First, it recognizes the defined territory of Taiwan. The scope of ROC territory was actually controversial when Taiwan and the United States negotiated the Mutual Defense Treaty, as the treaty only included Taiwan and Penghu and did not extend to Kinmen and Matsu, two small islets near China. The U.S.-Taiwan Initiative avoids the problem by simply stating that the territory is what Taiwan's representative represents. The initiative also recognizes the government. It includes references to government agencies in charge of defense and foreign affairs, as well as the president. Since 1979, about 370 agreements have been signed through two de facto embassies, technically NGOs, the American Institute in Taiwan, AIT, and TECRO, the Taipei Economic and Cultural Representative Office in Washington, D.C. What is unique in the U.S.-Taiwan Initiative is the use of designated representatives, allowing these de facto embassies to delegate their authorities to government agencies, including the USTR and Taiwan's Office of Negotiations. In other words, The agreement facilitates direct government-to-government talks, and the committees established under the agreement also institutionalize this dialogue. Finally, the independence requirement is also addressed, and this is often the most challenging statehood criterion for Taiwan. After the agreement, the PRC warned the U.S. not to conclude any agreement with sovereign implication or official nature. Sovereignty manifests independence. So even Beijing agrees that the agreement reinforces Taiwan's capacity to enter into relations. And these legal recognitions also enforce Taiwan's identity and status, and they further provide empirical support for the IR argument that recognition can take gradual forms. The first agreement covers 5 areas, and it is expected that the second agreement will cover the remaining areas, including agriculture, environmental, and labor issues. Many of these issues are also comparable to those under Trump's reciprocal trade agreements. It is generally agreed that although there are no tariff commitments, the agreement helps reduce trade costs by facilitating customs clearance. There are additional benefits and cooperation on top of the existing customs agreement and the WTO trade facilitation agreement. Examples include fewer formalities for express shipments and the recognition of electronic invoices and data. The agreement also addresses marginalized groups, such as indigenous peoples, and will complement an agreement called IPECA, an agreement to which Taiwan, Australia, Canada, and New Zealand are parties. The U.S. joined as an observer in 2024. A key human rights issue during the U.S.-Taiwan Initiative negotiations was Taiwan's treatment of migrant fishermen in its long-distance fleet. Many of these fishermen are from Southeast Asia, and several U.S. government reports have identified problems such as physical abuse and wage reductions, which violates the rights under the ILO Declaration and the Work in Fishing Convention. The enforcement of these rules under the U.S.-Taiwan Trade Agreement will also benefit Taiwan's potential accession to the CPTPP. So this research is about the intersection of recognition theories in international law and international relations using the recent U.S.-Taiwan Trade Agreement as a case study. And I hope it sheds light on the ongoing development of global regionalism and the Indo-Pacific strategy. I welcome your comments and questions. Thank you.
Okay, thank you very much, Pasha. You covered a lot of ground there, from Hegel to the CPTPP. But before we go to the present, I wanted to just pause a moment on the Hegelian analysis, because this was very interesting. I have to confess, I had to look up Hegel's ideas and how they entered into the question. Are you, with this idea that identity becomes established through recognition, and that this is the way international relations theorists think about states recognizing each other, are you expressing the view that that recognition of states, that statehood, for a state to be established as a state, it requires recognition of other states? Are you saying that this is your view, or is it just that this is how IR scholarship is viewing the situation? And then, as a corollary, are you arguing that Taiwan's trade and investment agreements constitute the necessary implied recognition, and therefore are you endorsing Taiwan's claim to be a state?
Mm-hmm. Yeah, in terms of a constitutive theory and declarative theory, we know that it's no longer a debate in international law, right? I was a member of ILA Committee on Recognition, and although we provided some examples about the continued pragmatic significance of the constitutive theory, but with international lawyers generally agree that the prevailing theory is declaratory theory. So I was quite shocked when I read IR literature saying that actually international lawyers got this wrong. right? Because for state action, they still find that the concept of recognition is important because the struggles for identity and status will actually motivate state action, right? So from their perspective, the constitutive theory is still useful, right? So it's not like what lawyers said, it's no longer relevant. Back to the trade agreements. And as I said, Taiwan currently has 9 FTA type agreements. Taiwan also has more than 30 bilateral investment agreements, as well as double taxation agreements. And I think it would be an exaggeration to say that all of these agreements would trigger implied recognition. But I think it would be reasonable for me to assert that the collective agreements will actually blur the line between non-recognition and implied recognition. And a very interesting issue about implied recognition is that implied recognition usually depends on the intent of the government. However, it is for the government to interpret its intent, right? So it depends on what the government says or how the court interprets the government action. So in practice, the government can sign extensive agreements with Taiwan, so long as it says it upholds the One China policy. There will be no implied recognition. Yeah. I think this is the approach of many countries when they engage Taiwan in many international agreements.
In practice, have the governments that have entered into these trade and investment agreements with Taiwan, including the U.S. government, have they accompanied their signing of these agreements with such a declaration in that moment that, oh, and by the way, we do this pursuant to our One China policy, or do they simply not bring that up?
Usually for FTA and for bilateral investment agreement, they will not include a One China policy in the agreement. But of course, they will have interesting arrangement for some sensitive terms, right? For example, how do you deal with investor-state dispute, right? If you don't use the word state in the agreement. So many countries in their agreement will use authorities instead of state. So this is quite interesting. Another interesting issue is about bilateral investment agreements. Usually trade or investment lawyers will know BIT, right? Bilateral investment treaties. But in the context of Taiwan, they often use BIA. A stands for where A means agreement or arrangement instead of a treaties, sort of a tone down the sovereign implication. So these are the practical arrangement they have come up with.
Okay, so these would be signals that the intent is not there for these agreements to be implied recognition.
Yes, I would say so. Yeah,
Right,
and of
right.
course, the different countries have different considerations.
Right. And what about enforcement of such agreements or arrangements? Because if one party to an agreement is not actually recognizing the legal existence of the other party, it becomes a little bit tricky to think about enforcement in law. So how does enforcement work?
Yeah, this is a very interesting question, not just for international law, but also for constitutional law scholars, right? Because when we talk about FTA or BIT, we usually refer to agreement concluded between two states represented by their respective government agencies in normal situations. But how Taiwan concludes these agreements, right? Using US Taiwan as an example, all the agreements were actually concluded not by government agencies per se, but by de facto embassies, representative offices, right?
100% of the time.
Exactly, AIT or Japanese Association Japanese Association dealing with Taiwan. So they are technically NGOs, right?
Mhm.
So from constitutional or administrative law perspective, can those NGO agreement bind the states, right?
Yeah,
So
yes,
it's actually a public law issue raised by some scholars. But so far, it only stay at the academic discussion level.
okay,
It's safe to say all the countries that have concluded all these agreements with Taiwan have not challenged the binding effect of these agreements. So I think I think it's more precise to say that they treat those agreements as if they were binding. Yeah.
right. Well, I flipped to the end of the first agreement between the US and Taiwan under the what is it, Framework for 21st Century. And I saw that there's no dispute resolution clause of any kind. Instead, there's a clause that says the parties will consult.
Yeah.
Consultations.
Yeah, so this is not a Taiwan problem per se. So this is
Okay.
the new approach of the Biden and Trump administrations. So now the U.S. are in favor of so-called new style agreements, right? So traditionally, we understand FTA, BIT. All WTO scholars are very familiar with these terms, but time has changed. The U.S. now clearly prefer those agreements, commonly known as mini agreements or sectoral agreements, right? So you
Mhm.
can't really classify them, and all of these agreements don't really have proper resolution mechanism. So they are quite different from FTA. But an associated question is whether or not um, this resolution mechanism under Taiwan's existing FTA are useful, right? So the most important case relates to Singapore-Taiwan FTA. So there has been a case brought under the investor state dispute settlement mechanism. So a Singapore government Singapore company sued Taiwan's government. So it's now pending uh, uh, at the PCA, right? So the case proved that the FTA resolution mechanism actually work and can be useful. Yeah.
Oh, that's interesting. That's very
Mhm.
interesting. So, do you believe that the Taiwan Authority, the Taiwan government, have pursued these kinds of agreements, whether they're BTA, bilateral investment treaties, or trade agreements, free trade agreements, or any whatever the format or name of the agreement? Are they pursuing these as a deliberate strategy to expand Taiwan's international recognition or to strengthen its status and legitimacy in the world? Or are they pursuing them simply because of the pragmatic need to have trade agreements to facilitate economic growth? What is Taiwan's intent?
Yeah. And the so-called domino theory usually help explain why Taiwan launched its FTA strategy in the 2000s, as Taiwan was quite concerned that the trade diversion effect of other FTA would undermine Taiwan's exports. But
Mm.
Tsai Ing-wen's new southbound policy emphasized concluding more investment agreement with Southeast Asian countries to provide better investment protection for Taiwanese companies. So the overall objective is to protect Taiwan's trade and investment interests and not necessarily pursue different form of recognition. But of course, those agreements, as I said, naturally come with different form of legal recognition, and which is also important to Taiwan.
Yeah. So in IR theory, and I realize this is theory, but is there any discussion of the practical applications or the practical value of implied recognition? I mean, it sounds very nice, but is it any use?
Mm. Yes. Okay. So implied recognition is actually an international term. So it's not an IR term. So implied recognition and explicit recognition are actually the same in terms of legal effect. Why it can be important? Because once recognition, regardless which type of recognition occurs, the entity such as Taiwan will be entitled to certain benefits, such as sovereign immunity claim, which is quite important, as well as diplomatic privileges and immunities, which are quite significant for Taiwan's de facto embassies and diplomats. Let me raise an example. Should Taiwanese diplomats pay taxes in the host countries, right? And can Taiwan use the diplomatic bag? And these are the very practical issues that Taiwan constantly faces, and implied recognition could help overcome this issue. But of course, all these issues have been negotiated bilaterally so far based on the current practice. But implied recognition will be an important threshold for these rights.
You know, you mentioned, because I was wondering if any courts had derived implied recognition from these agreements, but in your presentation, you mentioned this insurance, I guess it was an insurance policy that was being disputed, and it was made with a warlord government then controlling Beijing, correct? The
Yes.
Beiyang warlords.
Government, yes.
The de facto government, and that a U.S. court understood the U.S. government to have recognized the Republic of China, right? Now, but was that implied recognition, or that was actual recognition?
Yeah, that gets actually very interesting, and I found the case, which is the earliest two China problem case, right? But back then, the case involved two ROC governments, and this case was before the Court of Appeals for the Ninth Circuit, dealing with appeal from the U.S. Court for China in Shanghai. Right? Back then, there was a court over there, International
very interesting. Yes.
Shanghai settlement, right? So this is what happened during the Northern Expedition, right? So back then, the United States only recognized the Beijing government, which is the Beiyang government, right? And Chiang Kai-shek's government, Chiang Kai-shek's troop control Nanjing and Wuchang, and then demanded payment based on the insurance policy to which the Beiyang government was a party, right? So the U.S. insurance company did not dispute the insurance policy, but what it disputes is the party, right? And basically it say that, yeah, we signed the agreement with ROC, but the one we recognized was in Beijing, not Chiang Kai-shek's government in Nanjing, right?
Oh, I see. So the Beiyang authorities were claiming to represent the ROC. They were claiming to be the ROC.
Yeah, because back then, the U.S. only officially or explicitly recognized the Beiyang government.
I see.
And the court say that, well, situations have changed, right? So we see several new changes, including Chiang Kai-shek's minister was received by the president. We also signed the tariff treaty, okay? And all these will amount to implied recognition. So that
of the Chiang Kai-shek regime.
Of Chiang Kai-shek's ROC government.
Okay. Yeah. So implied recognition was deemed to be implied as opposed to formal, was deemed to be dispositive in that case. Has there been anything since then, or is that the only?
They are. I briefly mentioned that there are two interesting Singapore airline cases. Okay, so I am quite interested in this case because I teach it every year. The same facts, but two courts, right? So basically what happened is that Singapore airline crashed in Taiwan, right? So this case was about whether Taiwan can assert sovereign immunity in those proceedings. So this case occurred in both Quebec and Singapore, right? The facts are completely the same. And both countries also have state immunity acts. But the State Immunity Act do not define statehood. Instead, those acts say that if you have a problem, you ask the government to issue a certificate, and then you will figure out the answers.
Mhm.
And interestingly, both Singapore Airlines Council and Taiwan's Government's Council asked the government, Ministry of Foreign Affairs, to issue certificates. In both countries, the governments declined, saying that, so the answer is not yes or no. The answer is we cannot give you such certificates. And Canadian government say that, yeah, true, we have a one voice doctrine, but we can analyze what happened between Canada and Taiwan. We got so many agreements, right, based on the government dealings, and Taiwan should be entitled to sovereign immunity because Taiwan fulfilled the requirement of a state within the definition of State Immunity Act. But Singapore court came out with completely different decision, saying that, yeah, we also look at extensive agreements and MOUs between Singapore and Taiwan, but the intent of the Singapore government was quite clear. It does not intend to recognize Taiwan, even imply recognition. So Singapore court denied Taiwan's sovereign immunity claim. So the same case, very different decisions.
That is fascinating. So I want to start bringing in some questions from the room. And one of them is simply, what has been the mainland Chinese attitude towards trade agreements that do not imply recognition of Taiwan? Do they accept that kind of arrangement? Do they accept the dodge?
Well, I think mainland Chinese, the PRC has not specifically addressed this issue, but for them, the interesting thing about the PRC position is that there's no fixed position, right? In other words, red line can change. In other words, for Ma Ying-jeou's government, it's okay to sign agreement with New Zealand and Singapore. Yeah. The interesting thing is that I recently read a memoir of Qian Fu, former Taiwan's minister, 4-volume memoirs, and one volume talk about the agreement between Singapore and Taiwan, and actually Singapore got sort of an implicit endorsement from Wang Yi about Singapore-Taiwan agreement, right? That's why Li Guangyao actually called Ma Ying-jeou and telling him that we are about to negotiate the FTA, but Wang Yi requested that it's public because it's in the book. Basically, Wang Yi said that the Singapore-Taiwan FTA could not exceed ECFA, and both sides, Taiwan and Singapore, should inform mainland China on a regular basis. Right.
Okay.
So this is what, and this is what happened during the Ma administration. But for Tsai Ing-wen's administration and the Lai administration, I think the answer is quite clear, right? Any agreement with Taiwan will not be tolerated. And an interesting case is actually Australia, right? Because after Taiwan signed agreement with New Zealand in 2013, Australia naturally became a potential FTA partner, right? Because New Zealand FTA usually follow very similar foreign policy strategies. I also read another memoir of a senior Taiwanese diplomat, David Lee, who served as Taiwan's representative to Australia. And in the book, he said that he actually proposed the FTA idea to the Australian government 3 times, but got rejected because of the implicit understanding between Australia and Taiwan, so Australia and China, to keep some distance from Taiwan. Right. You can read the news article in 2018. Now Australia dropped the FTA plan with Taiwan. Right. So the short answer is that the red line can change, and there's no fixed position of the PRC.
Right. That's interesting. So the U.S. initiative, the U.S.-Taiwan initiative, as you mentioned, only has signed the first phase agreement. And that agreement was supposed to take effect, or I guess it did take effect in January. right ahead of the change of US administrations. Has there been any change in how it is implemented in that transition from Biden to Trump? Is the Trump administration continuing to honor it and to implement it?
Yeah, so this is quite important, right? After both sides concluded the first agreement in 2023, they started discussing the second agreement. So the most recent meeting took place in 2024. So now Trump came in, and Trump has a very different trade strategy, America first strategy. I think the whole world is trying to figure out what it is, right? But from what we know is that Trump is now negotiating so-called reciprocal trade agreement with various countries, including Taiwan. So there's no plan for Trump to abandon the U.S.-Taiwan initiative. And in fact, Trump cannot abandon it because there's a law for implementation act for the first agreement. But there is no update on the second agreement. But we should also be optimistic about the development, because I recently read the text of U.S. reciprocal trade agreements with Cambodia and Malaysia. If you compare them to the U.S.-Taiwan Initiative or IPEF, and there were actually quite a lot of overlapping issues, such as digital trade, labor, and environmental issues. So Taiwan will continue to talk about this issue, discuss those issues with the United States, just under a different agreement.
So they'll continue the conversations, but they won't be moving in the direction of having a second phase agreement under the header of the U.S.-Taiwan Initiative?
I don't think they are proceeding with the second agreement. The current priority
It's off the
is
table.
Yes, the second agreement I think is off the table now, or at least that the U.S. did not mention it at all. So the priority is negotiate the reciprocal trade agreement, right? So both sides, Taiwan and the United States, have conducted 5 rounds of in-person meetings for the reciprocal trade agreement. The goal is to get a deal probably by the end of the year.
Well, there was a statement issued, I think, from the Taiwan side after the recent APEC meeting that there had been talks on the sidelines of APEC, am I right? And that the Taiwanese side was quoted as saying that there had been an exchange of documents and that an announcement would come soon.
Exactly. So during the APEC meeting, the Taiwan's representative Li Xinyi also met Secretary of Treasury, right? And Taiwan's trade negotiators also met with counterparts from the State Department and the USTR. So they are exchanging the text and trying to come up with a consensus.
And would this reciprocal agreement cover some of the same ground? Because as you mentioned, the original plan for the second agreement was to be fairly ambitious, and it was going to cover these things such as the indigenous groups' rights and labor rights and so on. But we know that those are not priorities, or they don't appear to have been priorities for the Trump administration. So would those are now not in the picture? For example, concern about the status, the compliance with the ILO rules in terms of the workers, on the deep sea fishing fleets, for example, that kind of thing. Are they out of the picture?
Yes and no. Yes, the reason is that if we look at the reciprocal trade agreements, the recent agreement with Cambodia and Malaysia, there are still provisions on labor rights and environmental protection, right? So there will be provisions over there, right? Quite similar to what the second agreement envisioned. The answer can also be no, because if you look at these provisions, they are actually quite brief and abstract, right? So they are not as detailed as a regular agreement, such as FTA or the second agreement envisions.
Right. Okay. So Congress has been Taiwan's strongest supporter for decades, really. If not for Congress, we might not have had the Taiwan Relations Act even proposed, right? And then in recent years, we've seen a number of quite aggressive proposals from Congress for legislation to further protect Taiwan and its international standing. There was the Taipei Act, I believe, signed in 2020 under the first Trump administration, which was intended to promote Taiwan's international relations. It was intended to create incentives, kind of carrots and sticks, to encourage the countries that still recognize Taiwan to continue to do so, and then encourage other countries to step in and do so. But I think it's universally believed to not have had much impact for the simple reason that, well, the United States is trying to encourage other countries to do as it says, but not as it does. I mean, the US is not recognizing Taiwan. So it seems it's a little bit inconsistent, to be polite. So I'm wondering a couple of things. One is whether that thread of pressure from Congress is continuing in the Trump administration. Is Congress still trying to be the player in the room who is promoting Taiwan's interests? And would that have some effect on the trade agreement? Because Congress was pushing for an FTA, in fact, several years ago. They wanted a full FTA. So is Congress still exerting that kind of pressure? And in your view, is the Taipei Act having is there any chance for it to have any effect?
The answer is also yes and no, right? It's true, as you mentioned, that Congress has been a longstanding supporter for Taiwan. So Congress has passed various acts, including Taiwan Travel Act and the Taipei Act. But of course, the question is whether or not they are useful, right? So why they are significant? I think politically they are significant because it sends a signal to the administration that's the bipartisan consensus to support Taiwan. And if we look at trade agreement per se, the U.S. is not pursuing FTA with any countries. But those agreements show the U.S. support for Taiwan does change the momentum for other countries to step up their agreement with Taiwan. And so from Taiwanese perspective, the most notable examples would include Canada's recent investment agreement with Taiwan, which is called FIPA, as well as the UK's enhanced trade partnership with Taiwan. So they are all after the U.S.-Taiwan Initiative first agreement. So you can see a series of agreements that carry significant trade impact.
Do you think that they were in any way inspired or encouraged by the U.S. example?
They are encouraged, but as I told many of my American colleagues, that I think Canada is much more proactive than the U.S. now, right? And the U.S. has a very robust Indo-Pacific strategy, right? So far, we don't know if the Trump still has the Indo-Pacific strategy. And Canada is not shy about that, and Canada specifically say that the investment agreement with Taiwan is actually a key pillar of its Indo-Pacific strategy, right? So it's actually ahead of the U.S.
So I have a question here from the room asking, it seems that as long as economic benefits can be maintained, the Americans will remain a protector of Taiwan. That is, the relationship remains transactional. So does Taiwan need to remain relevant and helpful to U.S. interests continuously?
Well, the overall answer is yes, to a certain extent. Of course, Taiwan wants to be relevant. I think that many observers would pay attention to semiconductor, right? TSMC has announced a $165 billion investment in the United States. And recently, the U.S. government Secretary of Commerce also said that we want a 50-50 split in semiconductor production, but that proposal will not be accepted by Taiwan. And true, so investment commitments of Taiwan will be important to the Trump administration, but we also need to realize that it will not happen very soon because it will take a long time. But let me give you some factual information. It only takes 19 months to build a semiconductor fabrication plant, commonly known as fab in Taiwan, but it will take about more than 30 days in the US.
30 months?
30 months in the US, right? So much longer. And the new H-1B visa policy will also increase the labor costs. And cultural differences are another challenge, probably unknown to many American colleagues, that TSMC is actually facing a class action lawsuit brought by almost 30 US employees, alleging different form of discrimination, including the use of Chinese in the workplace.
These are employees at the new facility in Arizona?
Yes, and particularly Arizona. Yeah.
Okay.
So and so there are a lot of practical challenges, right? So we need to know there's a gap between what happened on the ground and between what happened on the ground and investment commitments. But overall, of course, Taiwan needs to be relevant to the US. But I would not say that it's not just for trade perspective. Politically, Taiwan also quite important to the US, right? So I think in our earlier discussion, we talked about the concept of American century, right? So in the article, I say that the fall of Singapore to Japan during World War II signaled the end of the British century. Okay, let me sort of clarify what I meant there. So what I meant is that the British surrender of Singapore to Japan made people in British colonies realize that they could no longer rely on the British Empire. And the decolonization movement eventually led to the end of the British century, as well as the empire. And if Taiwan were to fall to communist China, and US allies in the region would no longer trust US commitments and would either become part of the Sino-sphere or develop their own deterrent capabilities, such as nuclear weapon, right? So the US would no longer be recognized as a resident power in the Indo-Pacific. So naturally, it will be the end of American century, and this outcome would not be acceptable to any US leadership.
That's a powerful motivation indeed. And I know it's been discussed quite a bit in public, you know, what the implications would be. Let me, in the remaining minute that we have, just get in one last question to return to this theme of diplomatic recognition versus implied recognition. Can a country that, even one is as economically successful as Taiwan, can it survive over time if it does not have formal diplomatic recognition, do you think?
Well, Taiwan's case demonstrate that recognition is critical, but here recognition is not necessarily defined to diplomatic recognition. So this is the issue and the key point in my research. So what I try to prove is that there are actually different forms of recognition, legal recognition under various agreements, and all of these forms are important, right, to Taiwan from pragmatic purposes. So not necessarily diplomatic recognition, but those form of recognitions under different type of agreements.
That enable it to actually be in the world, to operate in the world, right?
Yes.
Right. Okay. So we're going to have to leave it there because our time is up. But thank you very much for this thought-provoking conversation. And I think we will return to some of these points again in our upcoming further episodes of Taiwan Legal. We will be having some more guest speakers on this subject in the spring. So Pasha Hsieh, thank you so much. And thank you to our audience also for joining.
Thank you very much, everyone, and Catherine.